You had a green arrow. You made the turn. The other driver ran the light and hit you. In Denver, middle of the day, witnesses saw it. The police report backs you up. 3 weeks later, the insurance adjuster files a report saying you were 30% at fault for the crash. That one line in that document just cost you $30,000 on a $100,000 case. Not because a judge ruled against you, not because there was a real dispute about what happened, because an adjuster wrote a number in a box, and Colorado's comparative negligence rule made it stick. Here's the part that should stop you cold. If that adjuster had written 50 instead of 30, you would walk away with zero, not a reduced check, zero, on a case with witnesses and a police report in your favor. The 50% bar is an absolute cutoff under Colorado law, and most people have never heard of it before it cost them something. Here's how the math works, how adjusters build that number, and what the documentation does to fight it back down. Colorado uses what is called modified comparative negligence. The governing law is Colorado Revised Statutes 13-21-111. Here's how it works. If you're partially at fault for a crash, your compensation is reduced proportionately. But at 50% fault, the law cuts off your recovery entirely. You get nothing at all, not a reduced check, zero. The threshold is not greater than 50%, it's 50% or more. If the other driver and you are assigned equal fault, you lose under Colorado law. Some states use pure comparative negligence, which still allows you to recover something even if you are mostly to blame. Colorado is stricter. Our 50% bar is an absolute cutoff applied to every personal injury claim in the state. The math here is simple and it is brutal. Take a $100,000 case. At 30% fault, you collect $70,000. At 49%, $51,000. At 50%, zero. 1 percentage point. In contested cases, that is often the entire fight. So the question becomes, who decides what your fault percentage is? In the overwhelming majority of personal injury claims, it's the insurance adjuster assigned to the other driver's policy. And that adjuster is not a neutral party. Insurance adjusters are trained to find fault on the claimant's side. This is not a cynical take on individuals. It's a structural reality. Adjusters are measured on how efficiently they close claims and how much they reduce payouts. When they build your claims file, they're actively looking for anything that supports a higher fault percentage on your end. That is their job. Here's how that plays out in practice. If you told the responding officer, "I didn't see them coming," that phrase goes into the file as a visibility argument. If there was any question about your speed, your lane position, or your reaction time, it gets documented and used. If you were making a left turn, adjusters will flag that default bias. If the road was wet, if the intersection was busy, if it was dark, all of that becomes potential fault ammunition. Casual comments you make in the first phone call with the adjuster before you have any idea how serious the case is can end up in that file permanently. This is not neutral fact-finding. It is a deliberate strategy built around a rule most people do not know exists until it's already cost them something. If an adjuster has already called you and tried to assign a fault number, drop it in the comments. I want to know what they told you. That is also why the recorded statement call in the first 24 to 72 hours is so dangerous. We covered that trap in detail in an earlier video on adjuster tactics. When you give a recorded statement before you have the full picture of your injuries, you can hand the adjuster exactly what they need to build an at-fault argument against you. What actually protects you is documentation, and the window to gather that is immediately after the crash. The police report is your foundation. It's also the first document the adjuster will review. Get one filed at the scene without exception. Photographs of vehicle position, road conditions, traffic control signs, skid marks, and visible damage create a physical record that is very difficult to dispute later. Witness names and contact information need to be collected at the scene. Witnesses documented in the first hour carry significantly more credibility than people tracked down a month later. Dash cam footage can be decisive. Both your footage and footage from other nearby vehicles, if you can identify them, can establish the full sequence of events in a way that is nearly impossible to argue against. Business security cameras and traffic intersection cameras near the scene are also potential evidence, but they disappear fast. Often within 24 to 72 hours, that footage is overwritten or destroyed. An attorney can send a preservation letter immediately after being retained to prevent that from happening. Medical records also matter here. If your injury has any overlap with prior treatment, adjusters will argue pre-existing condition. A clear record documenting your condition before and after the crash makes that argument much harder to sustain. An attorney's job in a comparative negligence case is to fight the fault number, not just the damages. When you have legal representation, the fault number becomes a target, not a given. Your attorney can formally challenge the assessment and demand in writing the documentation behind it. Accident reconstruction experts establish the actual sequence with technical precision. Medical documentation counters pre-existing condition arguments before they gain traction. And the litigation threat is real. Adjusters negotiate differently when the case can go to trial. I have seen attorney involvement alone move an assessment from above 40% to below 20%, based solely on documentation the adjuster had chosen not to acknowledge. If an adjuster has already told you that you're partially at fault, ask for their fault basis in writing before agreeing to anything. Do not give a recorded statement without understanding what you are handing them. And before you sign any settlement, talk to a Colorado personal injury attorney. Once you sign, that fault number is final. There's no going back. The next video breaks down exactly how case value gets calculated in Colorado. Medical bills, lost wages, pain and suffering, all of it. That is the next one to watch. If you're dealing with a fault dispute right now, our contact information is at cghlawfirm.com. Drop a comment. If an adjuster has already assigned you a fault percentage, what number do they give you? I read every one.